Okay, good morning again. This is Victor, and we will get started. The only preliminary is if there are questions, you can transmit those in the context of the materials as you're looking at them on your screen. And with regard to the materials on the screen and in the PowerPoint, I'm going to go page to page as I speak, but I'm not going to strictly follow the outline that is in the PowerPoint, and not strictly follow the materials, but they are certainly a reference point. I want to talk about three aspects of what's going on in the oil and gas industry as it relates to the two kinds of companies that you see in the industry. The first and more well-known kind of company is the exploration and production company. The second, which is also involved and also has any number of insolvency cases that are more difficult as far as restructuring goes than an exploration and production case, are the service companies. I think it's fair to say, and I'm not going to spend a lot of time because I think that people on the phone generally know that I don't think it goes too far to say that there is a 2008-2009 kind of mortgage collapse that has gone on and is going on in the oil and gas exploration and production business. The number of bankruptcy filings since mid-2015 is just extraordinary. The handouts that you've received, one is a handout of cases that have been filed from early 2015 until the early part of this month, and the second handout are 29 oil and gas companies or service companies out of a total of 50 that were shown as companies imminently in danger of filing. And with regard to that, even that list, one of the companies on it, Vinoco Inc., based in Denver, actually filed a Chapter 11 case in Delaware on March 18, showing assets of $100 to $500 million, liabilities of $500 million to $1 billion, and a second one, which is not on the list, but which filed 2 days ago, also in Delaware, is Emerald Oil. Emerald Oil, according to its Exhibit A to its petition, shows $405 million in assets and $361 million in liabilities. So the filings are continuing in great number and tremendous size, and there's certainly no end in sight. This morning, the price of crude oil was $38.75 on the New York Mercantile Exchange, and the price of Brent crude, a different indicator but of a similar number, was $39.73 a barrel. Each of those were over $40 earlier in the week and have gone down since then, based upon, for some reason, announcements of increased production and importing. And I'm not quite sure how or why that's happening given the prices that are being obtained, but that was the reason for even the very recent decline in the price of oil. One of the things that I enjoy about our practice, about the bankruptcy practice, for those who are strictly bankruptcy lawyers on the phone, is the ability to have an opportunity to go and deal not only with the bankruptcy code and its effect upon a business, but also the effect of non-bankruptcy law. And in the oil and gas business, the intersection of laws pertaining to oil and gas and the bankruptcy code is truly remarkable, and it has created a lot of confusion. It has created a lot of issues which have not been clarified. And while I will get to a discussion of it later, the one term that is so meaningful to bankruptcy lawyers, which creates the most confusion by far, is the idea of an oil and gas lease. Because when bankruptcy lawyers think about the word lease, of course they think about executory contracts in Section 365 of the Bankruptcy Code, and whether or not and how Section 365 is going to apply to the quote-unquote lease. But in fact, while we all know about Section 365 and leases, whether or not an oil and gas lease actually is a lease is not governed by the Bankruptcy Code or the definition or definitions in the code or common law of a lease. It is defined by applicable state law in places, of course, where oil drilling, refining takes place, and those are states like Texas, Louisiana, Oklahoma, Kansas, Pennsylvania, and certainly some others. And I will get into that issue during the course of my talk, but I think the first thing a bankruptcy lawyer should do when faced with an oil and gas situation is forget about the term lease as he or she might have previously known it, because all thinking about a lease the way bankruptcy lawyers traditionally do is going to do is create confusion and make it more difficult for you to either defend or advance your client's position, as the case may be. What are the things that have created this remarkable, momentous downturn in the oil business? All of it starts, of course, with pricing, and that pricing, which was $80, $90, $100, $110 a barrel as recently as 18 months ago, maybe 2 years ago, was something which stayed steady and didn't decline or go down in any manner, at least in this country, notwithstanding the fact that the United States has become, over the last number of years, one of the leading or a leading producer of oil, a leading refiner of oil and crude oil. And so supply has dramatically increased over the last number of years before the before the decline in the price started. And even though there was such a significant increase in production and such a decrease in the level of reliance that that certainly our country had on foreign oil sources, on OPEC sources, and that it became pricing became much less volatile based upon politics and things going on in other places around the world. In spite of the increased supply, the price still stayed up at very high levels. And so one of the things that did was encourage exploration companies to further invest, and that's what they tend to do anyway. It's one of the remarkable things about exploration and production companies is the extreme level of capital expenditures that they are constantly undertaking, and the relatively modest cash positions that they maintain, notwithstanding the fact that they are companies of 9 and 10 figures in their size in terms of sales, assets, and liabilities. Their cash reserves, because of how they reinvest their cash, tend to be very low, and that obviously, when the downturn comes, when the music stops, can become a tremendously difficult situation, because when you're caught without your cash reserves that you would normally need in case a rainy day comes, you have very little flexibility to withstand any kind of downturn, let alone the prolonged and dramatic downturn which has taken place, as I said earlier, over the last 18 months. So with that introduction to some of the things that have occurred, some of the specifics. A lot of the contracts, a lot of the leases that are made in the production area, and I'm going to go through some terms of art as it relates to terms of art in the oil and gas area that are not ones certainly which are going to be familiar to bankruptcy lawyers unless you've had an opportunity to work on an exploration and production company or service company case. But one of the interests that takes place early on when you're trying to develop and explore for oil is called a working interest. And a working interest in an oil field or in oil production can be any number of different kinds of interests that different kinds of parties hold. But one of the defining characteristics of it is typically that at the start there is a landowner, a person that owns the mineral rights that exist under the surface of the land, and there is the person to whom the owner of the land and the mineral right leases. And again, remember the lack of clarity in that word for bankruptcy purposes in this instance. Leases the mineral and oil rights to a exploration company for purposes of allowing them to drill and invest in drilling in the land down to the minerals in the hopes of accessing crude oil. Well, once that working interest holder obtains the lease, that company is going to take the lease, or that developer or that speculator, as the case may be, is going to take the lease and take the working interest and break it up into many, many, many component parts. And in fact, there's a case, 1993, Jones versus Salem National Bank at 6F3rd 422 and at 424 in the Seventh Circuit, which I think characterizes what happens with respect to these quote-unquote working interests. And again, to quote from the case, in attempting to convert dreams of black gold to hard cash, aspiring capitalists split the property interest in oil into more fragments than the atom or the rainbow. And that can give you an idea, and it gives me an idea to the extent I didn't have it previously, of what can happen in a bankruptcy case when you have so many interest holders in a property right held by a debtor, the property right being the working interest. You have so many different kinds of investors, interest holders, people who have different pieces of the pie, people who are responsible for production. There's just many different players in the scenario, in the situation where you're just starting out with what might appear to the uninformed observer to be a simple lease of an interest in mineral rights and real property. It's far more nuanced than that and much more complex than that. And of course, it's all around the idea of how do you generate the capital that you need to do this research, do the drilling, and ultimately, hopefully, hit the end product, which is to start farming crude oil. The division of these property rights, when it relates to the producer, to the company doing the drilling, requires the drilling company, and these are the companies that are filing bankruptcy cases now, to meet certain production levels. And if the production levels are not met within given time frames, the rights under the lease are forfeited. So as a starting point, and as one of the early indicators of things going south in a big hurry, is you have producers contractually obligated to produce and generate a certain amount of crude oil from a mineral lease, who are producing that crude oil at a loss because the price of crude oil goes down so dramatically from the beginning point when the contract may have been entered into 2, 3, 4, 5, 7, 10 years ago to the present point in time when it got down as low as $30 a barrel and is now at the $39 roughly level. It just creates, as a starting point, an impossible situation financially for any company to ever think about making a profit or able to stay viable in that context. A second issue. A lot of these companies, in order to finance themselves, because they're considered risky even in good times, are borrowing money, taking on bond debt at very high rates of return to the bondholders. As of the early part of 2015, the energy sector, and this is a remarkable statistic in my mind, accounted for more than 15% of the high-yield debt in the United States, with exploration and production companies responsible for 9.5% of that amount. In 2014, 18.3% of the high-yield bond debt issued was issued by companies in the energy sector. And in the latter part of 2014, just to confirm the obvious, energy yields during that time frame posted a return of negative 11.2%. So an additional important part of the perfect storm, besides the contractual issues that you're under and the production costs that are constant and fixed, is the fact that a lot of these companies have borrowed money at very, very high rates of interest, which become unserviceable by them when you have, again, a price of crude oil that's down and gone down as low as it has. I think in the Excel spreadsheet that was one of the two attachments that we circulated yesterday, you will see by the oil and drilling and exploration companies, the reason for their financial problems are in many cases defaults on bond debt, and besides the amount itself being owing, the interest rate just creates, again, another part of the perfect storm that has befallen the industry. The last part is that these companies, and this may be implied from what I've said already, are really constantly in need of capital. They're constantly in need of capital. That's why they borrow money at high rates, and they have to borrow money at high rates because the suppliers know how much the need is. They have constant needs for their credit lines and credit facilities, and it really just creates a very difficult environment when, again, the pricing is as it is, and when you go looking to try and access funds from any source that you can, whether it's from private equity, from your own credit line, that at least as it pertains to your credit line, even if you're not in monetary default, certainly as your company's balance sheet changes dramatically with the fall in the price of crude oil, you're probably going to be in a covenant default pretty quickly on your loan, and you're going to have great difficulty accessing your credit lines that are really one of the lifebloods of these kinds of companies. And so while some were able to withstand the call on capital that they had because their revenues were going down so much, while some of them were able to access capital and basically stay afloat, keep the balls up in the air for the first half of 2015, when you get to the second half of 2015 and so far in 2016, absent an increase, which has not happened, in fact, it's been just the opposite, in the price of crude oil, These sources of cash, either new sources, bond debt, newly issued bond debt, or certainly cash from their credit lines, has dried up altogether. And among others, bank regulators have taken notice of what's gone on and have put significant restrictions on banks in terms of loans they can make to this sector. And that has further pinched them significantly in terms of their ability to, again, access credit lines. So, I think from going over these, this just cascade of disasters that have befallen this industry since the latter part of 2014 and continuing into 2015 and this year, there's really no end in sight. There's no one out there who is predicting that there's going to be a change or a dramatic change in the price of crude oil. There's nothing even on the political horizon, God forbid, that will cause that to happen. So it's just, by all appearances, for certainly the better part of this year, going to be very, very rough sailing for companies in this sector, which is why out of the list that I prepared and the 29 companies or the 28 companies that were listed, that was 28 companies out of a list of 50 companies that were reportedly in financial distress, 28 of them in the oil, gas, and energy sectors. So, that really summarizes, as best as I can do it, the really difficult business trends that exist, the horrendous economics that are currently in place, and so I guess the question is, having now understood the problem, understood the business reasons of why we've gotten where we've gotten, what's going to happen in a bankruptcy situation? Well, one of the issues or problems in the bankruptcy context from an historical standpoint is that in prior downturns, such as in the 1980s, when there was a significant problem that was caused by the Iran hostage crisis and great investment as a result of that crisis in drilling operations by exploration and production companies, the price of oil went up and then in a pretty precipitous manner went down in the middle 80s, and as indicated in the materials on page 8, went down to $9 per barrel. Even then, the exploration and production and service companies that were impacted by that, and there was a remarkable number of them, a lot of the cases went by way of informal workout. And there weren't a lot of bankruptcy cases filed. They were basically, in most instances, matters that were resolved out of court. And because of that, there weren't the bankruptcy cases filed. There weren't the issues that I tried to highlight at the beginning of this talk that were litigated or dealt with in court or in court, and matters just weren't resolved that would give people clarity now that we have another dramatic downturn in the oil and gas industry. We don't have a lot of decisional law out there that really resolves some of the basic issues that are so problematic when the oil and gas business intersects with the bankruptcy code, and that intersection, of course, takes place in a bankruptcy court dealt with by bankruptcy lawyers and bankruptcy judges who may not be, and certainly are not, nearly as familiar with the laws, the non-bankruptcy laws that apply in this area, as would be the case if these matters were litigated matters in a Texas or Louisiana state court. And so you've got some difficult problems, and you've got the overlay of the bankruptcy code, and how do things work out when that takes place. So shifting in terms of my discussion to some of the things that take place in a bankruptcy case, I think it's important to go through some of the terms of art. And by terms of art, I mean non-bankruptcy terms of art, so that these are at least known to you, so when you see them, and when you see them, they will be, they will ring a bell, a light will go on, and you'll be able to, by being familiar with these points, be able to issue spot things that are going to come up for your client as a debtor or your client as a creditor or party in interest in a bankruptcy case. I give some of the definitions in the materials, and so that I don't forget, there certainly are additional materials I'm more than happy to provide. All you need to do is send me an email after the program, and I'll respond and send you additional materials that respond to whatever questions you have, particularly as far as these definitions are concerned. On the page in front of you, we give a definition of one of the important terms, but by far not the only one, a farm-out agreement. A farm-out agreement is an agreement entered into by one or more mineral lessees, or with respect to one or more mineral leases, called the farmer and another company who wishes to obtain a percentage of ownership of that lease or leases in exchange for providing services. The typical services described in a farm-out agreement is the drilling of one or more oil and or gas wells. A farm-out agreement differs from a conventional transaction between two oil and gas lessees because the primary consideration is the rendering of services rather than the simple exchange of money. And after some of the events of the 1980s, there was some amendments to the bankruptcy code. One of those amendments is the definition of a farm-out agreement in section 10121A of the code includes any agreement for the assignment of an interest in oil and gas that includes as consideration that which defines operations upon the property, and that'll be considered a farm-out agreement. So that's something that the code specifically addresses, but let me go through some other definitional points that you'll want to know about. Some of them I've referred to, some of them I haven't. Just to be basic to start with, a mineral interest. A mineral interest is an ownership, consists of the ownership of oil and gas that is in place under a parcel of property, typically in fee simple, and the exclusive rights to explore, drill, and produce that oil and gas from the land. Mineral interests are conveyed by a mineral deed after being severed from the surfaced interests. Though states classify these interests differently, the broad definition of property of the estate under Section 541 makes these distinctions moot for bankruptcy purposes, and mineral interests held by a debtor, even those that are contingent or non-possessory, are considered property of the estate. A working interest. A working interest is the owner of the mineral interest, often an individual landowner or government entity not in the business of oil and gas drilling. Usually these people, these entities, prefer that a sophisticated oil and gas exploration and production company handle the extraction of the minerals. The mineral interest owner in these situations grants the exclusive rights to explore, drill, and produce the oil and gas by conveying an operating interest or working interest to the exploration and production company. The cost of the exploration and production is borne by the exploration and production company. So all those are the production company's responsibility. Typically, not always, but typically what is paid to the mineral owner, the landowner, is a royalty. And the royalty is typically a percentage of the gross revenues, not revenues after expenses are deducted, which are paid for by the production company, but the royalty interest is an interest that's payable as part of the gross revenues of the company, and that basically is what they receive as consideration to them under the lease. Another term that you'll hear that relates to royalty interests is a term known as, quote, overriding royalty interests. Overriding royalty interests are typically carved out of the working interest by a working interest holder. As a general matter, quote, perpetual overriding royalty interests last for the life of the lease between the working interest holder and the mineral rights holder. But there are also term overriding royalty interests, and those by definition will be limited in their duration. I'm going to list a couple of other terms. I'm not going to go into them in as much detail. I don't want to, if you will, take too much time reading definitions to you, but they are terms that you should look for and do your best to familiarize yourself with. One of those terms is a net profits interest. It might be referred to as an acronym NPI. Another one are production payments, which is an interest created out of the lessee's estate, which is a share of the minerals produced from the real property. And let me just see if there are some further definitions I want to give to you. You will hear companies referred to as quote-unquote upstream companies, midstream companies, and downstream companies. And each of these kinds of companies live in a particular sector of the oil and gas business. Typically, the upstream company is the company to whom the mineral interest owner will lease the underlying mineral rights to. So that's the initial company that's going to drill for the crude oil. When the owner or the lessee gets involved with other parties, there is a document, form of agreement that they enter into, and this is important. It's called a joint operating agreement. And there is actually a form, which is a form that is promulgated by the American Association of Petroleum Landmen. The acronym, again, is AAPL. And that is an agreement that parties enter into for purposes of dividing up the revenues in a certain manner or a certain way by buying between any number of parties who want to take an interest in what the production company generates from the mineral lease. A midstream company is a company that engages in some combination of gathering, processing, storage, and transportation of hydrocarbons, oil, or gas. Terms under that you'll want to look out for are, quote, first purchaser, end quote. Second one, gas purchase agreements and tri-party netting. And you'll want to look at a case with respect to that I think we cite in the materials called SEMCRUDE, SEMCRUDE at 399 BR 388, which has to do with offset rights and how Section 553 of the Bankruptcy Code, which deals with the exercise of offset rights in a bankruptcy case, applies to a contract that permits offsets, and whether or not that offsetting that is permitted under a contract in the non-bankruptcy context applies in the bankruptcy context. There was an important recent decision that deals with these kinds of leases that is again cited in the materials, very recent, March 8th of this year, called Sabine Oil and Gas. I believe that is cited. I hope that is cited in the materials. It should be. and it doesn't have an official citation yet. I have, not in front of me, but can certainly get readily, the Westlaw or Lexis citation to it. It's a decision by Bankruptcy Judge Chapman in the Southern District of New York, and Judge Chapman considered whether 3 covenants or agreements between a debtor and a non-debtor for gas and condensation gathering services could be rejected under Section 365 of the Bankruptcy Code, and the issue there was whether or not the rights granted were rights in real property or rights in personal property. If they're rights in real property, Section 365 doesn't apply, something I'll get into in greater detail in a few minutes. If they are rights in personality, Section 365 does apply. So those are some of the points with regard to midstream companies. With regard to downstream companies are companies that most of us are most or more familiar with. They are the companies that deliver gas and oil from production and before delivery to the ultimate customer. The players in that particular area occupy overlapping roles. The most common are refiners, retailers, traders, and marketers. An example, of course, of a refiner is a recent filing, not that recent actually, but in 2013 or 14 by LyondellBasell Chemical. An example of a retail company that had any number of gas stations is a case called Flying J, and I'm sure notorious, if not well known, a company in the trading and marketing area in oil and gas was MF Global, which was a massive fraud case, but is at the same time a good example of what typically happens to companies that are in the trading or marketing of oil or gas securities. When they get into trouble, when they get too concentrated in one particular area, they tend to go into bankruptcy or simply go out of business, whether in bankruptcy or out. Their assets are just not of sufficient value to ever lead to a reorganization, and oftentimes aren't of sufficient value to sell for anything other than a bargain basement price. So having gone through the definitions, at least some of them that I'd like you to keep in mind, I want to go back to what happens and what are some of the things that arise after a bankruptcy is filed. And I think that with regard to a filing, again, as I said at the beginning, Section 365 is crucial, and how courts have and are presently interpreting Section 365 in the oil and gas context is creating a lot of confusion, a lot of uncertainty, and as a result, maybe to the cynical benefit of lawyers, a tremendous amount of litigation. The bankruptcy lawyers certainly know that Section 365 permits a debtor to assume or reject an executory contract or unexpired lease of non-residential real property of a debtor. If you look at a conveyance of oil and gas or mineral rights as a lease, Section 365 would of course be front and center in terms of how those lease rights are addressed in a bankruptcy case. But if you analyze an oil and gas lease that way, you're going to be in a significant amount of trouble, because that's not the way it works. The way it works is that one looks to state law to determine, non-bankruptcy state law to determine whether or not a conveyance of a mineral interest, whether to the upstream, midstream, or downstream company, is a lease governed by Section 365 of the Bankruptcy Code, or is an ownership interest in real property, and therefore outside the purview of Section 365 of the Bankruptcy Code. And I think a couple of statistics are important. The bankruptcy cases that have gotten filed at least up to the early part of this month from the early part of last year were filed by far predominantly in Delaware and New York. And even though they were filed predominantly in Delaware and New York, over 50% of the debtors were Texas companies. And that's going to have a significant impact for Texas companies and companies in any number of other states, where the question of what a right in a conveyance of a mineral interest is considered. Because in Texas, without any question, a conveyance or a right in an oil and gas lease conveys a vested interest in real property that is called a quote-unquote fee simple determinable. And the case I cited earlier in talking about an oil and gas lease being a misnomer, the Topco case in 1990, deals directly with the application of Texas law as it pertains to what an interest, what this kind of interest is. So you have Texas law on that subject. On the other hand, you have a case called Frontier Energy that is pending in the bankruptcy court for the Western District of Michigan. And in that case, the bankruptcy court considered what the nature was of an oil and gas lease under applicable Michigan law. And under applicable Michigan law, these kinds of agreements are rental agreements to use real property and are therefore leases within the meaning of Section 365 of the Bankruptcy Code. So you've got the Topco case on one side, the Frontier Energy case on the other side, as examples of what can happen in different states depending upon whose law applies as it relates to the conveyance of a mineral interest in a bankruptcy case and what the nature of that mineral interest is in terms of how the bankruptcy court is going to deal with it. Excuse me just a moment. And you will have, even in the case of Section 365, you're going to have litigation over whether or not an interest in real property, again, done for drilling for mineral interests, whether or not it is an executory contract, because you have the long time fight that bankruptcy lawyers are certainly familiar with, and that maybe even non-bankruptcy lawyers who've spent some time in bankruptcy court are familiar with, which is what is the definition of an executory contract, and is the lease which is found to be a lease under applicable non-bankruptcy state law nevertheless one which is an executory contract, because arguably the only obligation that the non-bankrupt party has, the owner of the underlying real estate has, is to receive a royalty. And if all they're going to be doing is receiving a royalty, is that still an executory contract? And there may be a question, and there are questions about that, and that issue certainly has been the subject of litigation. So I think in terms of Section 365, determining its application starts with the identification of the precise oil and gas interest in question and a thorough understanding of how applicable non-bankruptcy law that is in effect classifies that specific interest. That is a really in-depth, nuanced, specific analysis that's got to be done before you file a bankruptcy case if you're representing the debtor in an oil and gas situation where there are oil and gas leases involved, and if you're the non-bankrupt party who's going to be endeavoring to represent your client's interests in the underlying bankruptcy case, you really have to thoroughly analyze that, because there are just a tremendous number of permutations that you have to take into account, and be sure to, in substance, as we say, peel the onion and don't leave anything don't leave anything to chance. There are no bright line rules. There are no absolutes as it pertains to when and under what circumstances Section 365 applies. So I think it's really important, as I've said, to get underneath that issue as quickly as you can. The last topic I want to deal with, and I'll talk about one other thing before that, is this very unclear law, even less clear than the Section 365 issues, and that is when you talk about leases between a debtor and the government, and leases between the debtor and the government to drill for oil, to drill for minerals and hydrocarbons. There's two kinds. There's a lease on land within the United States, and there's leases on land on the, quote, outer continental shelf. And it's especially in that area where there's a great deal of confusion as far as how rights are defined with respect to those kinds of leases. On a practical level, before I get to that subject, which I think will be the final one I'll talk about, is simply the practical issue of what happens in a sale. And the sale issues can be very, very difficult. There certainly are bankruptcy judges in Texas, for example, which I expect is why cases are filed less frequently in Houston. I don't know the Houston judges per se. I don't know anything about them in great detail. I know much more about the Dallas judges and some of those folks personally. But there is a decision out of the Houston Bankruptcy Court in the context of a sale under 363 of the code, where the judge said, hold on a minute, there's the Lionel decision, there are all these old decisions that haven't been overruled that talk about when and under what circumstances you can sell assets under Section 363 of the Bankruptcy Code when those assets constitute substantially all the assets of a debtor. And we do this so routinely that it's rare, in my experience in the last few years, that non-debtor parties even raise that as an objection, even though it's a perfectly valid objection. Why are we doing this so fast? Why aren't we giving creditors and parties in interest the timetable and protections of a disclosure statement, a plan, a voting process to vet out exactly what the transaction is that is being proposed? The Bankruptcy Code doesn't only allow for reorganizations in a plan, it allows for sales in a plan. It allows for asset dispositions in a plan. So why are we going this fast Section 363 route? And that argument doesn't go very far or very well in Delaware and New York, but it certainly has gone pretty well for some litigants in Texas, and cited in the materials to you is a case called Gulf Coast Oil, where the bankruptcy judge there actually went through all of the 10 or 11 or 12 factors that a court is supposed to consider before approving a sale in the absence of a plan and disclosure statement. And that's the law that nobody seems to pay much attention to anymore. Maybe I'm being too cynical, but that has just been my experience in the last number of years. But it shouldn't be forgotten because these kinds of companies are extremely complex. The sales that are being done are huge. Certainly, in terms of dollars, there's a case presently pending called Quicksilver, It's pending in Delaware. There's a $245 million sale for all the assets of the company, and the asset sale is awaiting a decision by the bankruptcy judge. As I said, I believe it's Delaware, as to whether or not an oil and gas lease, again that term, can be rejected so that the buyer is not subject to the pricing and the difficult aspects of that lease relative to exploration on the property involved, which may impose either pricing, production, or other obligations that the buyer is not willing to undertake. And in the Quicksilver case, the buyer has filed a pleading that couldn't be more blunt. It says, if you reject this lease, judge, I'm paying $245 million for the assets, and if you don't reject the lease, I'm not. And so that, while that shouldn't play into the merits, bankruptcy judges, like all of us, are people, not machines, and they can't help but be influenced by what their view is of equity, as they might see it. So sales can be very troubling and problematic as well, depending, again, as always, upon what jurisdiction you're in. Let me talk just for a second, because we have about 5 minutes left, about bankruptcy cases and bankruptcy filings as it pertains to leases with the government. And this is really an area of complete confusion. I don't know any other way to put it. It is similar in the sense that the treatment of leases held by debtors in bankruptcy cases is governed by non-bankruptcy law, that being the state in which the particular lease or agreement is entered into. Where you have a lease on the Outer Continental Shelf, which the acronym for which is OCS, there is a law that was passed in 1953 called the Outer Continental Shelf Lands Act. And that governs what happens with regard to leases of property for production that is on the Outer Continental Shelf. And just so you get an idea of the magnitude of this, in 2013, 477 million barrels of crude oil were produced from the Outer Continental Shelf, and that was at that time, it's the most recent statistic I have, that was at that time 1/5 of our countries of the United States annual production. And these kinds of leases pertain to ocean water, the bottoms of ocean water, that are between 5 and 200 miles off of shore. So it covers a vast, vast area. The Outer Continental Shelf Lands Act doesn't cover every instance or dispute with respect to how a lease dispute or a lease issue in a bankruptcy case might be decided by looking at that law to see how it treats that kind of lease. What the law says is basically, with respect to anything that we fail to cover, the law that will apply is the law of the state which is appurtenant to the leased land that we're talking about. So in most instances, because these are the states where most land is appurtenant to of these kinds of leases, the two states' laws that apply are Texas and Louisiana. But the further permutation of that is that the applicable appurtenant state law applies as long as it's not inconsistent with the Outer Continental Shelf Lands Act. Well, in Texas, I've already told you that leases of royalties are considered interests in real property. Well, that's considered by the government, and the government's position in bankruptcy cases has been, as it pertains to Texas being the appurtenant state whose law would apply to things not covered by the Continental Shelf Lands Act, that's inconsistent with the Act, because the government takes the position that a lease of outer continental shelf property appurtenant to the state of Texas is in fact a lease. It is not an ownership in real property. Therefore, Section 365 applies. So you've got great confusion there in terms of the position that parties take with regard to 365 and whether it does or doesn't apply, and that then devolves into the issues of whether or not it is a lease, whether or not it's an unexpired lease, and finally, as I said earlier, that even if it is a lease, whether or not the lease is an executory contract because of the minimal obligations that the lessor, in this case the government, has, which is basically to receive a payment or a royalty. So I hope that hasn't created more confusion than it should have. One case that you might want to take a look at with respect to this is a case called Union Oil versus Morton. It's a Ninth Circuit case. I don't have the citation here. Happy to get that for you. Just ask for it, and I'll send it over. But that's a case that addresses some of these issues and is one that has been cited in subsequent litigation as it pertains to areas not covered by the Continental Land Shelf Act. I just want to conclude by indicating that there's are still, notwithstanding all I've said, things that I haven't covered just because of the time and the breadth, the just huge amount of material and issues that develop in these cases. But you certainly want to keep in mind that when you're dealing with a debtor, there are going to be derivative issues regarding derivatives, and hedging transactions that all oil companies do to protect themselves against price fluctuations is dealt with in the bankruptcy code in sections 362, 546, 548D2, and 555 and 560 relating to swap agreements and all the kinds of agreements that these parties enter into. Additionally, that I haven't had a chance to talk about are the environmental issues and the mechanics and materialmen's issues. And these issues are very significant and are going to be litigated issues that come up, especially the mechanics and materialmen's issues, because those liens, depending again upon the law of the state that is applicable, are going to have pervasive rights in bankruptcy cases that you're going to see those people early on appearing and being very aggressive in saying that their materialman or mechanics lien applies to the entirety of the property interest that is involved, and they're going to be as expansive and as aggressive in pursuing their lien as they possibly can, because of course that maximizes their chances and their leverage to get paid earlier than later. I thank everybody very much. It's a few minutes after 12. I've really enjoyed diving into this subject, drawing upon my experience, drawing upon the things that I've had a chance to research in putting these materials together. And again, I'm not seeing questions at this point, I don't think, but maybe there are. One second. No, if there are no questions, which of course is fine. If you want to email me with questions or email me to ask for materials, I'm only too happy to provide them, and I thank you all very much. I think almost all of you have stayed and listened to me for this entire time, which hopefully means that it should be interpreted positively. So I thank you all very much. Have a good day.